This was a fairly complex personal injury case where there were multiple parties involving 3 separate accidents. My client's accident was accident number 2. The very first accident that happened, accident number 1, was much more severe than ours. It was a fairly high-speed rear-end collision. My accident was a lower speed type of an accident. And then the very last accident was another low-speed accident where the plaintiff came at a stop behind another vehicle, and then it's claimed that the defendant let her foot off the brake and backed into the plaintiff's vehicle. So we have 3 different accidents. Initially, the plaintiff treated for what are called soft tissue injuries. Those are injuries that are orthopedic in nature but don't really involve broken bones or any sort of surgery usually. And so usually those cases are valued at a fairly manageable amount, of dollars, and they're not considered really large cases. But the plaintiff had a problem in that she liked to abuse narcotics, prescription narcotics initially. So initially it was OxyContin. So she would take a lot of OxyContin, she got hooked on it, and then before all 3 accidents, that is, she was struggling with trying to get off of the OxyContin. And then our 3 accidents happened. She then claimed that she was in an extreme amount of pain, that she needed help with addressing the pain. Initially, the doctors gave her more OxyContin, but then they realized that she was abusing the drugs, and so they started to taper her off, and she started using over-the-counter ibuprofen. She took a lot of ibuprofen for a very long period of time. Eventually, her kidneys failed because she was taking so much ibuprofen. And she, of course, blamed the kidney failure on the pain that she says was related to all 3 accidents. So we have, soft tissue injuries, and then we have this claim that her kidneys failed and that she may need some future treatment for kidney issues. Then her attorney decided to send her client to a neuropsychologist who frequently only works with plaintiff's lawyers. And he examined Ms. Kelly and said that as a result of, again, all 3 accidents, she sustained a traumatic brain injury and post-traumatic stress disorder. And what plaintiff's counsel then did was hired a vocational expert, again, somebody who was only hired by plaintiff's counsel. That vocational expert contacted the plaintiff's kidney doctor, psychiatrist, orthopedic doctor, and created a plan for a life care plan for future treatment for the remainder of her life. At the time of the 3 accidents, the plaintiff was in her mid-40s, I believe. So their claim for future treatment extended for another 40 years out into the future. After all 3 accidents, and I think it was about 9 months after the last accident, the plaintiff quit her job. That was when her kidneys failed. And so she was hospitalized for 2 months because of that, and she never went back to work. So now she adds this wage loss component on top of her orthopedic, kidney, head injury, and post-traumatic stress disorder claims. They give the wage loss claim to the vocational expert, who again adds that as part of the life care plan. And so altogether, the plaintiff's life care plan, I think was, if memory serves me right, was $1 or $2 million. The plaintiff's medical bills for all 3 accidents, around $120,000. And she was claiming that she was fault-free in all 3 accidents. So the significance of that in Washington is that if you have a plaintiff who is fault-free, and they say that they cannot apportion their injuries amongst the various tortfeasors who are responsible for their injuries, then all of the tortfeasors against whom judgment is entered is what is called jointly and severally liable for the entire amount of damages. It's a very unfair concept because, again, if you have a little minor fender bender, but then, within a short period of time, and in my client's case, these other 2 accidents happened within a year, if the plaintiff is saying, I was injured in all 3 accidents, and I don't know which of the 3 accidents caused my injury, but those 3 defendants are 100% liable for each of the accidents. Then all 3 defendants are responsible for the entire judgment amount, and usually they, whoever has the bigger insurance policy, will pay, whatever that amount is. Under the joint and several statute, that does allow for a provision. There's a provision in the statute that allows for defendants to prove what portion of damages is related to our accident. And that's really what my case was about. Not only were we trying to minimize damages, but we're also trying to apportion, trying to determine, convince the jury that of their entire claim, we're only responsible for a very, very small amount. So from a defense standpoint, we're kind of fighting a multi-front war in a sense. You're fighting the battle with the plaintiff on their damages, but you're also fighting a battle with the other defendants because if you have defendants that have a small policy, joint and several liability helps them because then they can hide behind larger policies. We were concerned about even going into trial, what effect COVID was going to have with our verdict. Are they going to get, a huge runaway verdict like the plaintiff was claiming? But and then when we started trial, it was part of it was remote, part of it was in person. Pre-trial motions and then jury selection was all done remotely. And then when the jury was impaneled, then we would actually present opening statements, the testimony of the witnesses, and then also closing statements would be live with just the attorneys, the judge, and the jury present, but all witnesses would be remote. So it's kind of one of these hybrids. Having to do oral argument and closing statement with a mask, that's hard. That is really, really hard. And as a lawyer, when you're, whether you're doing oral argument to the jury or if you're asking questions of witnesses, you're always keeping an eye on what the jury is doing. You're trying to read their faces, their body language, and they're all masked up. So it's really difficult to gain an appreciation for whether they're getting bored, or whether, a particular line of questioning is something that interests them. All you see is a mask with a pair of eyeballs. The witnesses also, since they were testifying by Zoom, that posed another set of challenges. One of the witnesses that we had that the plaintiff called to testify in support of their case, off camera, they were reading from some documents. And had that witness been in trial, we would have seen, hey, you're reading from a script, but I happened to see that particular witness kept looking down off camera whenever we asked questions. And so I asked him, if he was referring to anything. He admitted that he was referring to some documents that the plaintiff's lawyer gave him, before trial. And so the court more or less told him, no, can't do that. And, had he been better at reading his script, I would have never known that he was, being hand-fed information from my opponent. So, COVID trials, they pose a number of very unique and different challenges. As a defense attorney, I always play to objectivity. Plaintiffs, on a very fundamental level, always love to present evidence that's subjective. Pain is always 100% subjective. So they will testify about how this pain, is debilitating them or how it's affecting their life. And I have no way of verifying if that's true or not. I have no way. So from a defense standpoint, I am always presenting cases in terms of what is objective. What is objective about the plaintiff's claims? What is objective about their experts' opinions? And it's because a large percentage of people really do value objectivity. And so that really kind of, is in line with what my defense is. So interestingly enough, I actually was able to use COVID to help kind of push home a point.